This is the ESPN article, ACC's motion to stay Florida State's lawsuit denied. So a Florida judge denied the ACC's motion to stay Florida State's lawsuit against the conference on Tuesday as dueling lawsuits between the two sides continue to move forward. We know in the two respective states. The decision comes 1 week after a judge in North Carolina ruled the ACC's lawsuit against Florida State can proceed. Florida State filed an appeal on that ruling Tuesday. In Mecklenburg County, North Carolina, Leon County Judge John Cooper heard arguments Tuesday in the case filed by the Florida State Board of Trustees in Tallahassee, Florida. He did not agree with the ACC's assertion that the case in Florida should be temporarily halted while the case in North Carolina moves forward. So we've got the same situation in both states in regards to where these stand, and one big decider seems to be who gets to the finish line first. Big game James Coleman's here as well. We always appreciate James taking time out of his busy schedule. Den Media Group, everybody. James, how you doing today?
I'm doing good, man. Just I'm in the DR having a great time, getting ready to get back to the States though. So
okay. Sounds good. Nice. Well, Chris, let's leave.
George, you say?
Yeah, we making it. It's not too bad right now, like I said. But if there's a thunderclap and mine goes black, y'all know why.
Yeah. So, Chris, let's lead off with you in regards to determining, the impact of the latest here that came down on Tuesday.
Yeah, I think one of the best arguments that Florida State's lawyer, Mr. Rush, had was when he stated the fact that we were, technically, he brought up 3 or 4 cases, as much similarity as they could possibly have to this case with the ACC, but we're pretty much arguing over property. That property sits in the state of Florida, so Florida State sees that there's no reason why that this doesn't happen in the state of Florida, based on all the home games is what's covered under the grant of rights, not their away games, not anything else, not the bowl games, just the home games at Florida State right there at Doak Campbell Stadium. Or anywhere in the state of Florida they're considered a home team. That's what we're talking about. So his argument was we were arguing over property, and if you were renting or leasing property to someone in Florida, you wouldn't go to North Carolina or Tennessee to sue them for it. You would do it in the state of Florida. The ACC sued Florida State in North Carolina because they're a business, supposedly a nonprofit, that sued Florida State in North Carolina. Not that it's wrong, so to speak, but the reason the judge decided not to stay the case.
Did Chris get muted, or is that just on my end?
He's good.
So if he got the reason that it wasn't stayed was because the judge agrees that the argument's happening in the state of Florida for property that's in the state of Florida, and I think that the judge was very fair, and it's not because it leaned toward Florida State's way. Because I'll be dead honest with people, I didn't know. Watching the whole thing and listening to it, I didn't know which way he was leaning at all. And he ruled only on this portion of it because they literally took all day to pretty much cover this portion of it. So there's, 4 other complaints that have to be talked about. Luckily, that's going to happen on the 22nd of April. So just another week away, maybe 2, whatever it is. But I'm extremely excited for how well Florida State's lawyers did, the arguments that they made, and the judge agreed upon. The biggest one that I think caught the judge's attention for us to definitely not stay outside of, we're talking about property in the state of Florida, was that this is $700 and something million that the Florida taxpayers would have to pay to get out of this conference because we're a public entity. So the judge is like, yeah, there's nothing more material than money, right? So we as a state shouldn't have to pay $700 million to leave, but that's what it would be essentially. So I'm really glad that our guys on the offense this time, because I point this out every show that I'm on, including mine multiple times. We have to remember that in North Carolina, we're a defendant. In Florida, we are the plaintiff. So it's a little bit different strategy going into both of these cases, even though it's technically over the same matters. When one area you're defending yourself and the other area you're attacking. So I like seeing us on the attack much better than being on the defense. and maybe it was because we're in the state of Florida. I don't know. But very pleased with how our lawyers responded in the hearing this in Leon County.
George, I should have gone back to the previous ruling that was about 10 days to 2 weeks ago in North Carolina. So correct me if I'm wrong. The court in North Carolina basically ruled the same thing. So it was in the ACC's favor in North Carolina, correct?
Yeah. So you bring up a good point, and that's kind of actually exactly where I was going to go. You're getting, and it's kind of what we talked about going into this trial date in Florida, you're getting kind of the absolute reciprocate of what you got in North Carolina, just to what Mark's saying. The judge denied our motion to stay in North Carolina and said, no, there's no reason. This thing can't be held in North Carolina. They made the case for the fact of this is where the business is held. Florida State's flown up here to see the grant of rights, to do meetings over the years, et cetera, et cetera. And the judge he moved in their favor. He denied our motion to stay. And the same thing, as you alluded to, here in the state of Florida, and as Chris was saying, we're the plaintiff, as opposed to the defendant in that case over there. And the judge down here ruled in our favor to dismiss their motion to stay. The big difference there being priority, being the kind of key word that he talked about. In North Carolina, the judge, he didn't really like their rush to the courthouse, but in the end, he ruled that their second meeting that they took to kind of ratify that initial suit, it went backwards. It ratified the initial lawsuit, even though they didn't go get that true 2/3 membership vote to file suit in that preemptive race to the courthouse suit. He gave them that. The Florida State judge didn't so much. He gave, as Chris said, he gave us the plaintiff status, denied their motion to stay. So that was a really big part of it. Another big part that I really loved about this judge, that it was a lot different than Judge Bledsoe up in North Carolina. Judge Bledsoe really kind of let these guys make their cases. He would stop them here and there, bring up different things if he didn't like something he heard, but really kind of let everybody make their cases and left it kind of ambiguous. He really didn't show his hand too much outside of a couple, kind of jokes here and there that had the gallery laughing. Total opposite with Judge Cooper. Some people like it the way he did it in North Carolina. I personally like the way Cooper did it better. He just kind of really got down to brass tacks, pushed past all the semantics and look, we're going to get these two parties together and we're going to figure this thing out and we're going to figure it out today. Now, he didn't get to all three motions as we've talked about. He only got through the first one. But he really got, for example, the ACC lawyers out there and made them kind of spell out, okay, what is the exit fee? Yeah, it's 130 to 140 million. Okay, now what happens if FSU leaves? And this is kind of what has been brought to light, and kind of the question that two people could look at this case and have different opinions on how the grant of right is. We've talked a lot about how the grant of rights goes through 2036. Okay, but my opinion on it, the way I've talked about it, it really only goes through 2027 because ESPN has until February of 2025 to extend this thing. Well, the ACC made the case in court yesterday or Monday, whenever it was, that should ESPN decide not to extend this thing come February of 2025, the rights come right back to the ACC and they can shop them and sell them to anybody they want. So Apple Network, whatever the case may be. But if you look at how Clemson filed their suit, and if you're to kind of believe their interpretation, which has now become our interpretation of it, this grant of rights is tied to ESPN. It isn't something that you can somebody else can come in. The first 10, 15 pages has ESPN some hundreds of times, like that. So there is a side of looking at this, that those contracts are indelibly linked to each other. So I thought that was really cool. They didn't get into a ton about kind of the future rights. The judge made a lot of jokes about, the choke it doke and what are the old games worth? $1 million? Seems like he kept trying to give rope to the ACC lawyer to get frank and get down to the facts that, look, it's the future games. It's how can they go to another conference if the ACC owns their rights? So I thought he did a real good job of that, and just can't wait to get to Discovery. And I'll shut up. I could talk for hours on this, but yeah, very interesting.
James.
Yeah, I just did my whole show this morning was with the lawyer, Florida State grad, Doug Rohan, about this matter. It was so crazy that we barely scratched the surface of like what happened. How do you condense an 8-hour hearing? But the biggest thing is just to take a step back. So if Florida State, so if you look at both trials, so North Carolina, where the ACC filed, in Tallahassee, where in Florida, where the FSU filed, both won. And basically all this was like there was no winner. I mean, let's just put no game. If we put this in football terms, there has been no game played. What's happened was North Carolina won the coin toss, and they elected to defer, and Florida State picked. Not necessarily where if they wanted to kick off or if they wanted to return the ball. That's basically what happened. We haven't. So just to go back to how civil suits work, and again, I'm not a lawyer. I know a lot of them, but I've been sued. So here's how civil suits work, in particular in the state of Florida, but most states are similar things. I lay out my grievances that have happened to me. And the only way I can get a stay is kind of just, I want this to hold off until something else happens. But dismissal means I have true proof that those things did not happen to you. Not like, but you put so many things out there that something did happen. So in the ACC's case, Florida State wants to leave. So yes, we know that. So that's basically to summarize their complex case. Summarize, Florida State wants to leave. Florida State didn't come and say, I don't want to leave. Like, that would be the only way you can dismiss that. Same thing now when you come to Florida. Florida State saying that they lack the fiduciary responsibility amongst a lot of other different things. And the only way you can really go is like, if there's 20 things, you have to be able to prove without a shadow of a doubt that those 20 things did not happen. And the ACC knows that they can't do it. But as Doug said, 98% of the time, you sue me, I countersue, and this is just how this thing works. And then the whole goal, and I think the other part of it is the reason why it didn't get two different summary judgments and stuff like this. I do like the way that the North Carolina judge handled it. It made it more concise and things of that nature because he knows this is going to probably go in this direction. Now, the way that Judge John Cooper handled it here in Tallahassee was a little different. And here's why I like it. It's too long. I don't want to be in court that long. But that's why I'm not a lawyer. But he's making them flesh out arguments. And it's essentially what's going to happen is you're going to have to show your hand more. And he made the ACC admit to certain things on record. So one of the things is I would have advised, or my attorney probably would have advised me to just say nothing on this. When he talked about emails, getting into that, well, we don't have access to them. They're on a secure server. And he's just like, well, I don't explain to me how emails work. It's like he's doing these things basically saying, so the ACC has admitted they have the correspondence. They just don't know. What they're saying is they don't know how to get it. Now, if this goes to a jury trial, you are literally showing that if you don't present this stuff, you're showing guilt by default, so they're going to have to show it. So again, you got that on paper. He also made them specifically define a lot of the different things that are going there. This is property here in the state of Florida. We have specific laws. He also did something that the North Carolina judge didn't do, was he cited case law. Like, they cited case law. And one of the things that was really interesting, which I think might be too much of a stretch, but it's out of pocket. Not out of pocket, it's outside the box, is that he didn't use. So your case law, typically you want to find things that judge has ruled on that are similar. Then from there, you find things in the circuit court that has been ruled on that is similar. Then from there, you go on. But this man went on ahead and took federal, not trademark, patent cases and used those. So none of the attorneys were ready for this. So he actually is showing them that you're going to have to come with your A game on this because this is what I do. This isn't just a sometimes thing. So I liked it. I just wanted to preface people saying winners and losers because there has been no game played, essentially. Now, I will say the one caveat in North Carolina, that to put a dent in the ACC's argument is when the judge basically said Florida State doesn't owe you any fiduciary responsibility. Like, so they can't argue. That's a big part of their argument is that Florida State owed them this. Now, moving forward, like not moving forward, but going back to the Tallahassee, they talked about, and George brought it up, they talked about the grant of rights basically in the 2027 thing. Like, what does it cost to get out of the conference? They gave a clear number of they have to pay an exit fee. So, okay. So with the exit fee, what does the exit fee get you? It gets you out of the conference, but then you own these games. Well, then what is the so what is the exit fee really buying you? What is the actual cost to get out of the conference? And they could not answer that, because what happens is they said the GOR and the media rights is different. That being said, the GOR is public knowledge. Like, it's public info. Anybody can get it. And I'm taking what Doug said. And he's tweeted this. The problem with the and George just alluded to this, it's actually paragraph 7 in the GOR, basically states that, let me read this because I don't want to say it wrong, I'm over here sounding attorney-ish. The GOR was made at the request of ESPN for the benefit of the ESPN and in conjunction with ESPN. It mentions ESPN 7 times, not any ACC affiliated media partners. Going down to specifics of being able to go on campus, there is and again, what's funny is what's used in this trial and what's found out will be used in North Carolina. So what the ACC says in Florida, and this is the problem with lies, not lies necessarily. The problem with being in court is that these people trip up your words, and that's where the ACC's lawyers were getting frustrated, because I've done this to lawyers. One thing lawyers hate doing is when you lawyer them and you make them have to talk. And any lawyer will tell you, the more you talk, the more they're going to be able to flip your words. But when they said that if ESPN doesn't re-sign in 2027, then we get the rights back and we can sell it to anybody. There is no language in the GOR that states that they were willing to do this. In the GOR and throughout it, there's only one mention of one media entity, and that's ESPN. So you can't go, and if we want to argue that the contract, which is what you're trying to say you played out, you can't go back. You can't vote this one. You can't go back and vote 2/3 vote to say, okay, now we want to be able to sell it to Apple. We want to be able to sell it to this. We want to be able to sell it to these people. You have so basically what Florida State is going to argue is that there is no contract past 2027. Because if ESPN doesn't extend it in 2025, like this is all. So now ESPN has to figure out, this is the problem with this going so far. And even more so with Discovery is that the ACC is essentially effectively deading itself the longer that this goes on, because we know Clemson and Florida State don't want to be a part of the ACC. Potentially North Carolina doesn't want to be a part of the ACC. Those are 3 huge brands that are a part of the ACC between basketball, football, baseball, softball. Why would I extend when I know that these guys potentially might not be here? So there's no reason for me to do business with you or give you a comparable deal. And again, and that's just talking about that from things that the judge made the ACC say. But the bigger part of this is there is no, like the ACC can't even tell you how much Florida State has to be able to pay for their freedom. And that's one of the questions that kept getting asked. And again, it's going to be tough to play this out on multiple fronts. Even if it goes federal, like it's still going to be like they got another case, and I believe he's going to have limited discovery. Because John Cooper stated, I want to see some of this stuff before I make my motion to dismiss discovery or these different things. The problem is there's cameras everywhere. So even if they have to bring this stuff up, it's discovered. Like you don't need Sunshine State laws when you have local TV, War Chant, and all these other people in here live streaming it.
Streaming live.
The information that you're going to have to speak. And Clemson seeing all of this. The longer this plays out, all they're doing is just setting up. If Florida State loses, Clemson is literally seeing everything that they're going to have to play. And they're going to win. So, and if Clemson wins, a Florida State loss doesn't matter because now there's an effective way to get out of the conference.
Hey, Chris, since you're only here for a part of the show, I want to, of course, give you the floor to say whatever you want to say. And if you don't have anything to say, I certainly have questions or clarifications to make. But if you have anything that you'd like to bring up here, go right ahead.
I'll say a short piece of what I thought Florida State did really well on as far as their attorneys go. Again, I was excited for the fact that Rush got up there and he argued the fact potentially that Florida State's not under contract at all because according to the Constitution of the ACC, which is supposedly what every bylaw that they stand for and go by is set for, they were supposed to have Florida State's Board of Trustees vote on whether the university could re-up basically in 2013 when they amended the contract. That the president at the time is the only person that read it and or signed it. So they're stating that, or we as in Florida State are stating that there was basically an error. Like the ACC knew the rules, Florida State knew the rules, but Florida State didn't even know that the meeting was happening for the president of the university to sign to extend our membership. I think that one's a stretch a little bit, but the argument is still there based on there was no meeting and there was no vote held. So what does that mean exactly? And I like that Judge Cooper said, well, we'll get deeper into that basically on the 22nd, because if the same way that the ACC did not have a vote previous to suing Florida State, getting 2/3 of the vote, that our lawyers also pointed out, not only are you supposed to get at least 2/3 of the vote of the members, but you're supposed to have their board of trustees and so on, 2/3 of them also vote for it as well, not just the presidents of the university, because that's how it took place. None of the other members, I won't say none, but the majority of the other members that voted for the ACC to continue on into the amendment, which wasn't even the complaint in the first place, the actual lawsuit, they went back and tried to get a vote done, which was 3 weeks later. And that becomes a whole nother issue because they didn't do what they called the security of even filing a lawsuit, where Florida State did. They had a public meeting. They did everything the way that they were supposed to. So technically what they're trying to say is the lawsuit in North Carolina should be completely thrown out because they didn't do their duty as far as getting a secure vote and doing all the things according to their constitution and their bylaws that they created themselves as in the ACC. So I don't know where this is going to go. I'm just here for it and love being able to talk about it. And trying to remember 8 hours, like James had pointed out earlier, trying to condense 8 hours of what happened. I'm trying to use the best points that are what my favorites were. George and James both covered a multitude of those. So I just like the fact that we're able to put this amount of information out there in context. Hopefully, we're not confusing people just as much as the way that the lawyers speak. Hopefully, we're putting it in better terms that people can understand exactly what happened.
Jackson, thank you so much for being here. We appreciate you. And Jackson just wants to watch football. So he says 136 days until the start of the 2024 Florida State football season. Of course, that's going to be in Dublin, Ireland against Georgia Tech, a co-member of the ACC for now. Okay, I want to clarify something James was pointing out that we've kind of alluded to in the past to a certain extent, because my legal knowledge probably has now definitely become fourth in the room because of all that you guys have taken in over the last couple months, and especially considering this case, but especially once Clemson got into this matter and the ACC had to fight on basically 4 fronts at the same time. My thought was, wow, the ACC is going to have to be consistent with its information and its argument here, 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 and here. And even though technically they're only a defendant in 2 of the 4 situations, I think overall they're really a defendant in all 4 as it plays out. It's Clemson and Florida State on the offensive here. So that's a difficult position for them to stay consistent and keep their argument consistent across all these fronts.
Yeah, and again, it's especially when you keep moving the goalposts. There is gray area in legal. That's why we have precedent. That's why they use case law. But like typically when you write your contract and you're saying that somebody hurt you, but you keep moving the goalposts upon what that hurt actually is, it typically doesn't work in your favor, especially when if it goes to jury and it's not just a judge. Now, one of the things that could just, again, I know there was a time, like I think they said 30 days to file for it to be federal, but I believe what's going to end up happening is if it's the case that it goes in North Carolina and it goes in Florida, North Carolina's judge rules in favor of the ACC, Florida's judge rules in favor of Florida State, they're going to probably go and say that this has to, if there's both will file appeals, and then it'll probably have to go federal. That there's going to be a judgment, but I'm going to tell you what's going to happen in the state of Florida. I don't know what happens in North Carolina, but they'll set a case, the trial date at a certain amount of stuff. They'll do discovery, but you have to go to mediation before you go to trial in the state of Florida. There is no like skipping that. You have to go to mediation because they don't, and they're going to really force this because they don't want to, again, 700 with the potential, I think it was a little exaggeration, but $700 million in taxpayer funds, they're going to want this to get settled without it getting to that point. But in mediation, now the cool thing about mediation is you can say whatever you want to say. And if it's not in discovery, they can't say that you said in mediation, blah, blah, blah. You have to prove what they said in mediation. But like it gives you more free reign to speak about what it is. But that's why I believe that a deal will truly be done before it actually gets played out in the trial. Because when you start adding in the Raycom situation, because even John Cooper asked, was Raycom Sports really the best that the ACC could do in putting their ACC network up? Is CW the best? Like, who are why would they be upset if you were so perfect? And on top of this, with the biggest, actually, it was funny because going back to the original GOR, which Florida State is going to hammer in both courts. And they're going to hammer the ACC on whoever defends the ACC GOR on this. So there is no court of provision. So, like, if you think about, like, if you look at your credit card statements, most credit card, if the credit card company does wrong by you, you're going to have to go to court in Delaware. They literally clearly say, if you sue us, this is where we have to handle it. The reason why? Delaware has more leniency toward them. Same thing with, like, if you get like a rental car or something. Florida, the state of Florida has more leniency on those, so that's why they'll do that. You see where the different companies set themselves up. They literally copied the Big 12's GOR verbatim. And this is what the ACC said. Do you know what's in the Big 12's GOR? Look, like, this is where, if you have to leave, this is where it's going to be at. So it wasn't an incompetence thing. It was literally clearly left out. And they left it out in the GOR, which is the playbook, or basically the prenup agreement. Like, they basically said that we don't, like, hey, we don't think this is necessary. So they messed it up, and they're going to hammer them. And again, if it's jury and you got to be able to find fault, like, they're going to be like, well, why are we here in North Carolina when you said that basically the school gets to pick where they're at? So the judge can say all he wants, but they want the people to rule on the fact. And that's kind of crazy. But this is, again, and then Florida State also immediately on Tuesday, while they were in court, they filed to the Supreme Court to review the judge's decision in North Carolina as well. So it's just it's going to be interesting and fun to see how this continues to play out back and forth. But again, I want to reiterate that nobody's won or lost anything. The game has not been played right now. We've done the warm-ups, we've done the coin toss. The band is playing a little bit. We're about to guys went to the locker room. They're about to run to the sidelines here before they started off. But we learned more about the case because it's 8 hours 8 hours of talking than we did because I think in North Carolina it was like each side got like an hour and a half, and then they got their rebuttals and then things of that nature. So it was a much shorter and much more concise thing than what's going on. And Tallahassee is going to have multiple cases, so like we're going to talk about this all over again after the ACC, after the FSU spring game. So, I might stay in Tallahassee to go try to see if I could just. Well, actually, no, I won't. I'm not going to be in court for 8 hours for something that I didn't do. But I am intrigued by it.
Well, I hope that works out for you. I don't like to hear that.
No, I'm saying Tallahassee, like the 22nd, not for me. I'm saying the 22nd is when FSU got it. I was saying I would go because I'll be in Tallahassee for the spring game. That's the Monday after the spring game. But then I thought about it. No, I'm not. I don't like courts. So I don't want to go in. I'm not going in there. I'll listen. I'll get an attorney to come on and speak on my show about it.
Chris, George, we'll get you guys to weigh in on this one. James as well. Obviously, you're all welcome to weigh in on everything that I bring up. But Chris, I know, has to go at some point. So James brought up the buyout. And we know that the exit fee is $140 million. And then it seemed as though that they couldn't get past that in regards to determining what that exit fee is. Well, isn't it pretty, at least fairly clearly stated what that total package looks like? And I would think that the math would either look something like this from the ACC's vantage point, that you are costing us X number of home games over this many years. The ACC contract is worth this amount of money divided by 14 teams. Boom, this is how much you owe us. Or your home games on these TV networks are worth this percentage more than the average team in the ACC. Therefore, you're going to have to pay us this amount of money. And that's what the exit fee, at least from the ACC standpoint, would be.
Yeah, what I would say is what Florida State's going to argue, no matter what, the numbers, whether it's 572 million, whether it's 750 million, no matter what the number is exactly, because they wouldn't clearly answer the question as James talked about. We have a pretty good idea of what it is, and it's around the 572 million mark. So that's why when you take the 572 and the 140 to get out, you're just, I guess, plus of 700 million. That's why Florida State keeps using that number, because based off what they have, that's what it says. Florida State's argument is going to be is that's until 2036 that we would owe you that amount of money for those home games. And whatever the percentage may be, whether it's based off of our likeness and how much viewership we get and how much they actually make, or whether that just be the percentage of being a member and those home games are all allotted the same. Regardless of that, what Florida State's going to argue is we don't have a DOR or a media rights deal until 2036. We only have it until 2027. That's going to be their argument. And I think Florida State has a great argument, because even though the ACC has until February 1st, 2025 to make the decision, ESPN has that opportunity to make the decision in 2025 on February the 1st. The issue still lies that means we don't have a media right deal until 2036, because you have no one to pay for the media rights. No one is buying our games beyond 2027 at this point. So Florida State's going to push the fact that none of us, any member of the ACC, no one is under contract until 2036, based off of we don't have anyone on the other side of the contract. Who's the contract with? ACC trying to argue that it's with them. The problem is the ACC cannot play those games into the portion of paying us what all the members would deserve. So I don't think whether it's in North Carolina or whether it's in Florida, or hell, if we do it in Timbuktu, if you have any type of common sense, it tells you this is a one-sided contract. Beyond 2027, that is bare minimum that you have to understand out of that. Like, they have all the options and opportunities to do whatever they please. The reason I don't think ESPN is going to sign it, because they actually could have signed it on March 28th, and they decided not to. They said no. We're going to push it to the full extent, which Jim Phillips came in and said, all right, well, we're going to push it till February 1st of 2025. That didn't happen until this year. Or a lot of people are saying that's been there. It hasn't. That's untrue. They were asked on March 28th if they would go ahead and re-up it. They said no. The reason they're saying no is because everybody that's on this, at least, podcast that we're speaking on, everyone knows that ESPN doesn't make enough money off of ACC games. They may make enough off of Florida State. They may make enough off of Clemson. And they may make a little bit off of North Carolina and Miami. But beyond that, it's still not enough to uphold the amount of money that they would have to extend the contract to 2036. So, and if Florida State and Clemson are going to leave, regardless of whether there's a contract in place or not, the question still remains. It states also in the bylaws and constitution of the ACC, the moment that someone or one of the members withdraw from the conference, their media rights goes with them. They have contradictions. That's their problem. Their grant of rights versus their constitution, it contradicts itself multiple times. And I'm just using the biggest one that our lawyers brought up. There's such a huge contradiction between just that one focal point. And that's Florida State's they keep hammering on that. And the issue is they haven't gotten to that point in North Carolina yet. And that's, I think, what they were waiting on. And here in the state of Florida, they got to it right away. Mr. Rush did not waste any time on getting out what he wanted to get out. And he did it in a great manner. And I'm just pointing out the best pieces, in my opinion. There's so many good things that were said. There's so many things that they put out there that made sense. And I think Judge Cooper appreciated it. And I'm not going to lie to anybody that's watching the show. I think the ACC's lawyers did a great job of arguing their side of it. It's just, you heard Judge Cooper at the end. On this situation, I'm leaning toward Florida State. Y'all both did a great job, but I'm leaning toward Florida State on this one. And he did that three times outside of ruling not to stay the case. So it lets you know more than likely he's not going to dismiss this case. It's not going to happen. So all 5 amendments or complaints, 4 of the 5 so far. One he's judged on, ruled on. The other 3 that he talked about, he's leaning Florida State's way. So what's the 4th one? We didn't get to any part of that. We didn't get to any portion of it, which is the dismissal. So why would you rule on the not staying the case? How would it be dismissed? So I don't think that that's going to be something that Florida State has to worry about. I think that the case is going to move forward. That's just an opinion and prediction. I don't know that to be factual. It's just we're leaning Florida State's way too much. Even the North Carolina judge kind of leaned toward Florida State on, just like we had no fiduciary toward them at all, toward the ACC. They hated that part because that means we don't owe them nothing. To be honest, if you were going to sue us for any type of money, basically the judges said it was non-material harm to the ACC. So I don't know what the ACC gets out of this other than holding us here until 2027, because I don't see ESPN or anyone for that matter like, yeah, let me go buy the ACC's media rights when they don't have Florida State, Clemson, and potentially others. No, I don't think anybody's going to want to do it. So I don't think anybody's going to touch that until after this is all over with. No, we'll talk to you after this is all done, but we ain't doing it right now because we don't know what you're worth, because we don't know what you got, and that's the biggest question. So,
well, yeah, for sure. April 22nd, as James mentioned earlier, is the Monday after the spring game. So that's what we're going to get to hear in Leon County Court. The other 2 motions, the motion to dismiss, and then the motion for stay of discovery. And that's a good place, kind of what I want to go. I guess it's the last thing to cover. It was kind of glossed over. I think James mentioned it at a minute there. ESPN wasn't in the courtroom in Tallahassee. So take that for what you will. They didn't even show up to try to get up there to argue to keep things sealed or whatnot with the Sunshine State laws. The judge really, when it came to, it wasn't, we haven't got to discovery. We haven't even got to that conversation. But yeah, he did kind of hint at, like, are you really telling me back then that when y'all were trying to figure out how to make money for the conference, Raycom was the best option? That's who ESPN said, that's who they want to work with. And it got real kind of awkward and quiet in there. So you can only imagine once you get to that conversation about discovery and kind of the difference in this judge. The North Carolina judge, quick, but those guys pretty much got up there and read their arguments. The first thing this judge said was like, look, I've read all your briefs. I've read all of it, all the tons of pages. So if you start reading off of that, you could just go ahead and stop. We're going to get to stuff outside of that. He really put his feet to the fire. We kind of were wondering with Florida and the openness of media, the Sunshine State laws, like how much access are we going to get? Well, you want to tell me, like, what was ESPN, what was the ACC's butts? They were puckering up when the judge starts talking about all that stuff. It's streaming out live. I mean, there's nothing you can do. As soon as that thing gets said in the courtroom, whatever it is they're trying to hide, I mean, it's out there. I mean, and that's their only leverage, is keeping this thing secret. The judge even made the comment a couple times when the ACC is asserting, oh, well, it says in the agreement this and that. He said, okay, well, did you provide me with that? Well, no, we're just telling you what's in it. So, when you look at the dates and the kind of the chance of this, the chance of a settlement, I think this has just been another kind of huge momentum pusher, whatever you want to call it, a huge jet propulsion towards that finish line. Because if this court, the second court date, goes anything like the first, what we're going to learn from that whole stay of discovery hearing is going to be there's going to be some bombshells dropped, and the judge, he's just not going to let ACC get away with talking their way around things. He breaks it down into common sense, and he's going to make them answer for it, and they just don't have the answers, especially within that ESPN agreement and how it applies. They keep wanting to go back to the grant of rights is public, but so what's in the locked room? Oh, well, that's the ESPN agreement. Okay, but I thought so. Go ahead, James.
Sometimes when it goes to the jury, it's not about who's right or wrong as much as it's about showmanship. Now, one of the things you can't do in court, I don't know if you can do this in North Carolina, but I know you can't do this in this, or you're not supposed to be able to do it. You'll hear a lot of objections. Is like what George just talked about. Like, okay, I don't have, you have to, if I ask you a question about the media contract, or you speak about the media contract, you cannot speak in vague. I have to have a copy of it. You have to be able, so like whether it's locked away on Sunshine, they block it from Sunshine State laws. Court, you can go look up any court case. Court cases are public record. All they're going to do is just ask every detail of the damn ESPN media contract. And you can't say like, well, in our media contract, it says that we'll get paid $500 million or whatever the market value. Okay, where does it state that in the contract? Which paragraph, which page, which line? Because if you say it, I have to be able to read it in order for me to give a retort. And that it's clear Judge Cooper's going to be able to say, yeah, you have to hand that over. So it's a lot of things that once this gets to trial, I mean, it's going to be a very interesting thing, but we won't know more until the 22nd. And, when the judge decides if he wants to dismiss the case or a stay on discovery or all the different things. But I know that the judge wants to, because again, now the scariest part about it is I've already read everything. I know what you got, and he's able to speak intelligently on both sides things, which means that when this goes to discovery, he's going to do his research and know a lot more as opposed. Like, I'm not saying the North Carolina judge was lazy. He's going to be a guy that has experience, and he's going to go look it up or have his office look it up to what's similar. And I think the federal case law that he dropped, where he talked about, again, this as more of a patent right issue, and it's a reach, but it is something that is similar. Like Florida State, I can't just go Florida State's so patented that I could get in trouble for using the letters, not the letters. What do you call it? The font, the Unconquered font. They own it. So much with patents, you have to have trademarks. You have to have a bunch of other different things. You can't just go around and use Florida State for monetary purposes without getting permission, the express written permission and things like that with Florida State. So it's going to be a lot of stuff, and a lot of this is going to probably set precedent as college football continues to change into its reverse Pangea. So anybody that knows what Pangea is, basically where everything was one, spread it out. But right now, it's really going to go into a Big 2. And there's going to be schools in the Big 12 because again, there's a lot of similarities in the Big 12 contract because it's literally verbatim outside of the provisional law agreement, verbatim of the Big 12 contract, GOR. So you'll see maybe a couple of teams from the Big 12 say, hey, we got to get out of here because the other thing that's not being said, it hasn't been used and will be hammered in court, is the ACC Florida State doesn't owe a fiduciary responsibility, but the ACC does. And if you are saying that you are one of the top conferences and Florida State should be happy, then you should not have taken less money in the college football invitational than the Big 10 and the SEC. You were okay with it, taking less money. And so is Big 12. So there's going to be a couple of schools that are at the top of that say, you know what, while we may finish middle of the pack, we ain't Vanderbilt. I can tell you that much. We ain't Purdue out here. Like we know we bring more from the value and a lot of these other different things. So I wish life could just be as simple as just playing ball.